Is it visible? Is it visible to participants? Hello.
Yes. Please go ahead, sir.
Section 337 of the BMC Act 1888. This section pertains to getting permission from the municipal corporation to put up any structure, any new structure that is to be put up, whether it's a multi-story structure, whether it is a small house or a bungalow or even a farmhouse or whatever, or some small cottage. Any structure that has to be newly built, permission will have to be sought from the Municipal Corporation of Greater Mumbai in Mumbai limits, where the Act applies and where the corporation extends its boundaries. So this permission is got by filling up a particular form. As you can read it over here. You can read the slide. The person who shall intend to erect a building shall give to the commissioner notice of his said intention in a form obtained for this purpose under section 344. So there is a specified format. Those forms you will get at the corporation. You fill up the form, and normally this work is done by architects, because a layman cannot go about complying with various requisitions of the corporation and various other authorities. But it is not impossible for an individual to do. There is a format, you fill the format as per section 344, which pertains to getting permission under 337 to build, to construct any new building. In that, you have to mention the dimension of the land, etc., the size of the building, the road setback, how much, what is the width of the road, and things like that. And what comes over there, for example, gas pipes or water pipes or some water or cables or whatever is there, all that has to be mentioned. Because those things would, if anything comes on the plot of land that has to be developed and where the construction is supposed to come up, if anything is coming across that or in that portion, which is likely to cause a hindrance, then the commissioner will not accept your application. In this chapter, to erect a building means newly to erect a building. And this doesn't speak about demolishing old buildings and constructing or adding extra floors on some building or something like that. That would come under repair permission. This section is most often than not for new constructions. So the section reads, as you can see, the section, any building by demolishing the existing building entirely or by demolishing the entire building entirely. So emphasis is laid on demolishing the entire building. Any building, removing the roof of the existing building and expect to add one more up close or to re-erect, to convert into more than one dwelling house. A building originally constructed as well as a dwelling so erected, re-erected or converted is called in this chapter a new building. So even if you're going for redevelopment or whatever, if you have an old structure over there, that structure has to be demolished right to the ground level, to its foundation. Then and only then it can be considered as a new building. So when you're seeking permission for a new building, you seek it under section 337 of the BMC Act 1888. Now, there are various sections. 342 is there for repair. Then 347 is there. Then 351 is there. Something if you have done something illegal while constructing your building, not complied with some rules, not complied with the building proposal rules or any other rules, MADA rules or whatever rules you might have. In such a case, the corporation will serve you a notice. Now, if you are in the field of your law, you will understand what kind of notices are to be served, who serves what kind of notice on whom. When the corporation is serving you a notice, it is completely different as to when you are serving a notice on the corporation. Because when you are serving a notice on the corporation, you have to give a statutory notice. And if the corporation is serving a notice upon you as an individual or an institution, they don't have to necessarily give you a statutory notice. And what constitutes notice is defined in notice. If you have a background about notice, then you will know as to what constitutes a notice, what constitutes good or effective service of a notice. Now here there is scope in the BMC Act, there is a scope to cheat. Scope to cheat. I will not teach you the scope of cheating because we are not here to teach wrong. Nevertheless, I'll just give you this hint so that it will stimulate your mental faculties. And you think your own way of as how you could abuse the law within the provision of law so that you don't do anything illegal, because what is immoral, what is immoral need not necessarily be illegal. As you are aware, I'll give you an example. Suppose I have committed a theft and I'm taken to the police station and I'm taken to I'm giving a crude test, just a crude example. If I was taken to the police station, if I was taken to court and etc., everywhere I can decline to make a confession. That comes under Article 20 surplus 3 of the Constitution of India. Now that is not actually is morally wrong, but legally right. Because the law says that an accused cannot be compelled to adduce evidence against himself. So taking protection of that, I can abuse the law. Similarly, in this BMC Act, if you want to abuse the Act, there are various ways of abusing the Act, because the notice is supposed, if one is supposed to give a notice, they only say you are supposed to give notice to the corporation. How you're supposed to go give the notice, it has not been specifically drawn out or spelled out. Notice can be even oral. Notices at times can be in writing. Even if it is a writing, yet it might constitute an improper notice if it's not addressed properly to a particular officer or to the corporation itself or to the registered address of a company or corporation or statutory body. So there can be any number of reasons why pertaining to the irregularity of a notice, which vitiates the notice. So one should be careful when one is giving notice to the corporation, and one should also be careful when the corporation gives you a notice. So in this case, we have to give notice on the corporation that we intend to do a construction. So you fill up that form, you submit that form along with the requisite demands that have been made there, the requisite information data that is sought from you about the width of the road, whether any gas pipes are there, drainage pipes are there, any well is there, or any other electric cable is running along that. What is it? What is the FSI that you are entitled? All that you mention, and you give your notice to commence. Thereafter, they will scrutinize all the documents and give you what is called an IOD. Actually, the IOD is more of a misnomer. it should read the abbreviation for IOD is intimation of disapproval. Strictly, you should say, one should have said, it would have been proper to say, grant of approval, rather than intimation of approval, rather than intimation of disapproval. But as you know, BMC, how they work, all government departments work in such a manner, they will twist things out of context and keep themselves safe. Therefore, they have drafted that thing and they have designed that form in such a manner, IOD, intimation of disapproval. So whatever they disapprove, they tick in that window. Thereafter, you have to comply with. Then and only then the permission comes. Permission meaning CC, commencement certificate. You can commence your work. So for this, you have to mention who is the architect, who will be the supervisor on the site, etc., etc., etc. All that will come in the form. You don't have to worry about that. Then next we go to section 342. 342. 342. Notice regarding execution of work not amounting to erection of a building. Here the language employed is notice regarding execution of works not amounting to the erection of a building. That come under 342. Full stop. Every person who shall intend to make any addition to a building or to change or of existing user, or 3B, to make any alteration or repairs to a building involving the removal, alteration or re-erection of any part of the building except tenantable repairs. Except tenantable repairs. Now here they are giving you an exception. Why they talked about tenantable repairs? In the first place, tenantable repairs are not to be done by you. It's to be done by the landlord. Okay. But there are other ways of escaping this. Now, that I will come to you, I will point out to you in the case law. How people have sought to play with words and change the meaning of it. That I'll show it to you at the end of the lecture. How a particular plot of land was sought to be projected, or rather they put forth an argument before the Honorable Court stating that this is a slum and therefore the Slum Act applies to it. Now, as to whether it is a slum or whether it was a slum or whether it is going to be included in a slum, these are hypothetical questions. You see, and on the date when the application was made, was it a slum? These are questions that will arise. In that particular case law that I'm going to point out to you at the end of the session, it says that the person applying for permission to do some work wasn't the owner of a structure nor the owner of the land, and therefore it was declined. Now, this is no argument. This argument is okay for people who are laymen or quasi-judicial. Like municipal officers sit in adjudication over this kind of disputes. In my time, if I'm not mistaken, I used to appear before the DMC, Deputy Municipal Commissioner. Notices that come regarding this 351 and 342 are adjudicated before the Deputy Municipal Commissioner. But now I find in some reports, or what you would call case reporting. Either it could be a mistake or it could possibly be correct also. I cannot say, because today what we have is what was earlier a ward officer today goes under the nomenclature of assistant municipal commissioner. The same person, his designation has changed. Earlier we used to call him ward officer. Wards, as you know, there are various wards in a municipality, in a municipal corporation. A ward starts from Kulaba, and then you have B ward, D ward. D ward is at Grant Road, C ward is at Chandanwadi, and then H ward and K West ward at Andheri, and it goes on like that. So each ward has a ward officer. Earlier they had a ward officer, but this ward officer designation has now changed to assistant municipal commissioner. Matters were adjudicated before the commissioner, who himself is a party to the proceeding. So in one sense, just try to look at it in the sense it is amounting to a breach of principle of natural justice. Because the corporation is serving you a notice, and the corporation official sits in adjudication in a quasi-judicial capacity. So there could be an error of judgment and miscarriage of justice. Because you cannot get absolute justice when somebody is sitting in adjudication over a dispute wherein he has some interest. The interest of the corporation is to the extent that their officials have served you the notice, claiming that you have not complied with something or you have done some illegality, either one of the two. Now that could have been done by either due to a genuine reason, or else it could be done with an ulterior objective of creating hurdles for you, introducing some artificial impediment and creating hurdles for you. So we are not on the point as to what we are not on the point as to whether it is artificial hurdles are being introduced by the corporation or its officials. Beyond the point, as permission is required under 342 for repairs. Now, what constitutes repair? It's such a broad term. You can mean and include anything into repairs. What will be repairs? If you remove the wall of between two rooms, would that amount to a repair? If you touch the ceiling, do some repair to the ceiling, would that amount to repair? Plastering to the ceiling. If you do something with the pillars or the beams or the flooring, would that amount to repair? What constitutes repair has not been defined anywhere. Of course, those definitions you can get by way of various case laws and judgments have come in order to satisfy what constitutes repairs. Because there was ambiguity, and this ambiguity was being used by the officials to frustrate the cause of the applicant. For whatever reason, I'm not into that. So as you move an application under 342 for repairs, sometimes some official might even say painting also constitutes a repair, and you need permission even to paint. They have gone that far at times, just to create a problem, so that you come and approach them and you beg at them and cajole them and things like that. These issues go before the ward officer or the assistant municipal commissioner. But when the notice comes under 351, it essentially goes before the DMC, Deputy Municipal Commissioner. Now here, the Deputy Municipal Commissioner, if it is coming under 351, the Deputy Municipal Commissioner is required to give you 7 days notice. And you have to reply it within 15 days. With your reply, you are supposed to annex various documents in support of your reply. he has to essentially give you a hearing and peruse the papers before passing a speaking order, not just a two-line order, not just a sort of run-of-the-mill order. He has to pass a speaking order after having given you an opportunity of being heard at length and also perusing all the documents. And that should reflect in the order. If that fails to reflect in the order, you have great scope to get redressal by going to city civil court or else to the high court. If you go to the city civil court, you can go by provisions of the BMC Act as a suit and asking for an injunction also that the structure put up by you or the alteration made by you or the new structure put up by you as the case may be ought not to be demolished. For that you move a notice of motion in cities of Bombay. In Mofussil, the same thing is known as is given another name. Exhibit 6. Yeah. Which we call notice of motion in Bombay city. So here I'll take you to repairing. Now you see repairing, they say about tenanting repair. Nowadays, even as per a particular case law, gunneting to a structure member of walls, that also is taken as a repair. Gunneting to the structural members of walls, plastering, painting, pointing, changing floor tiles, repairing WC bath or washing places, repairing or replacing drainage pipes, taps, manholes, and other fittings, repairs of or replacing sanitary water, plumbing, or electrical fittings, and replacement of roof with the same material, but shall not include a change in horizontal and vertical existing dimensions of the structure, replacement or removal of any structure member of load-bearing walls, lowering of plinth, foundation, or floor, the addition or extension of mezzanine floor or loft, and flattening of roof or repair of roof with different material. Additional information and attendance of the person who gave the notice may be required. Effect of non-compliance and with requisition under 338 or 340. Notice to be given to commissioner of intent to make additions, including for change of user. That was inserted by Bombay Act 1905. To make any alteration in a building involving the subdivision of any room in such building so as to convert the same into two or more separate rooms, the conversion of any passage or space in such building into a room or rooms, to remove or reconstruct any portion of a building abutting on a street which stands with the regular line of such streets shall be given to the commissioner in a form obtained from the purpose under section 344. So here we find that the corporation officials have a great vast area to play with. They can raise objections about your painting. They can raise objections even if you change your uh, toilet. They can raise objections if you change even the sink in the kitchen or whatever. Slightest repairs or slight or even making of a what you call loft for the purpose of storing water or any other material. Anything and everything can come within the ambit of violating 342. So then what exactly is 342? For that, matters have gone to court and courts have decided as to what exactly it is. I'll take you to 347. 347. I'll take you to 347. No person, the section speaks about no person shall commence to erect any building or to execute any such work as is described in section 342. Now 342 we have seen what all they are permitted and what all they are barred. But that is not conclusive. That is just suggestive. It could mean and include even more things than mentioned in that section as shown up in the slide. Until no person shall commence to erect any building or to execute any such work as is described in section 342. Then you have A. Until he has given notice of his intention as hereinbefore required to erect such building or execute such work, and the commissioner has either intimated his approval of such building or work or failed to intimate his disapproval thereof within a period prescribed in its behalf. So when you give your notice of intending to build or repair or whatever the case may be, it is mandatory that the authorities give you a reply. No reply would mean deemed to have been granted. So this you should understand and play the game accordingly. Some people deliberately do this. So, file an application and keep it pending. They will not pursue the application. And you know how lethargic government officials are. Your application can collect dust for months and years, and nobody would ever care to open your application or go through it. And that is to the disadvantage. That is to the advantage of yourself if you know how to use the law. Put in your application and don't say anything until 15 days have passed, until one week has passed, until 15 days have passed, until 1 month has passed, because maximum is 1 month period. After 1 month, if he does not give you permission to do what you have requisition, you can go ahead and do it because it is deemed to have been granted. When he sends you the 351 notice for having done any illegality, immediately you can point out his fault, the date of your application and his failure to reply up to so and so date entitles you to go ahead and carry out your work. So on the basis of this, if you approach the court and point out that your application was made on a particular day, here is the acknowledgement of that application that it was received by the corporation on a particular day. This many days have lapsed in compliance with the section. The failure to intimate the applicant whether he is being declined or not, or whether it is being granted or not, that in itself constitutes one fault of the corporation. Not only you have to intimate that it is not being approved, merely intimating the party that it is not being approved is no intimation. The intimation has to be very intricate and assign a reason for which it is being declined. They have to assign a reason. It has to be a speaking order. That it is being declined because the road width is so much. It is being declined because you don't have that much of FSI. It is being declined because the person assigned by you to carry out the construction is not qualified from the engineering point of view, civil engineering point of view, or is not a licensed architect or whatever. But they have to assign a valid reason. And if they don't, then your scope of getting an order from the court is far better. if you take up these points, that the application was made on so and so date, this many days have passed, there was no communication forthcoming from the corporation, as per the law, section so and so, I am entitled to proceed with them without seeking any further consent or without further intimation, because non-grant of communication between the corporation and myself is deemed to be a grant of permission. So if you know the law, then you can take advantage of all these things. A repair permission. They have mentioned that many things in repair permission, 342, the section that I shown you above, the last slide. So, but as I told you, that section contains lots of things: painting, changing tiles, changing this, changing the roof, breaking the walls, or whatever, doing replastering, changing your sink, even changing your toilet seat. That also is deemed to be offense. But when matters went to court, court was very liberal in its interpretation. Merely changing the style of your commode, if it was Indian style and you made it an English style, that cannot constitute an offense by no stretch of imagination. So courts have been liberal in interpreting, whereas the officials, they are very narrow-minded and rigid in their interpretation, because they have a different point of view. They are not for the public. They are to protect the department, and they take great pleasure in introducing impediments and introducing difficulties in your life. You're supposed to. He's gone now. 1 minute. Hello, are you with me? Hello, audience, are you with me?
Yeah.
Okay. I hope you're not gone to sleep after a good meal. Achha, so you are required to do this within speed. When they serve you a notice under 351, first you reply the notice, and it's addressed to the Deputy Municipal Commissioner. You reply the notice, you annex all your documents along with it, and you have to have a hearing. In spite of the hearing and in spite of perusing the documents, if the DMC finds that if he finds some fault with your reply or whatever, or the documents, he's supposed to give you a speaking order. Thereafter, you have 15 days to approach the city civil court in Bombay City. And once you file it in the court and it gets numbered, then the matter is sub judice. Of course, you cannot that merely matter being sub judice doesn't entitle you to get any protection by way of corporation being prevented from demolishing. For that, you have to move an urgent application, which is taken up either next day with sometime an ad interim order passed by the presiding judge, honorable presiding judge. An ad interim order is passed without even hearing the corporation at times. You're mere filing it and putting up for hearing. Where an ad interim order is passed, no action to be initiated until the parties are heard. And notice is served on the corporation. Therefore, thereafter, corporation may appear, may not appear, because the municipal corporation has its own advocates. And there is, of course, a government pleader also. The corporation may, you know how the corporation functions. Their corporation advocates have 50 matters, sometimes 60 matters, 70 matters. So they cannot devote that much of time. And not only that much of time, I don't want to say anything about the quality of work. I have no right to speak about quality of work. But by and large, the matter goes on and on and on. So what you got is your protection. Your ad interim protection becomes your interim protection. that protection is carried over as an interim protection, not necessarily until the final disposal of the suit, but at least you get an interim protection till the parties are heard. So when the parties are heard and all these factors are brought before the court and is agitated properly, if your advocate can present your case properly and nicely, convincingly, there is probability of getting a good order. One of the ways of getting a order is to raise the issue. Now, another important point is to be pointed out about that the corporation is biased on the ground that error was committed by their officials themselves. The default of this suit, the default of these permissions and the default of grant of permission occurred due to the malfunctioning of your officials, and that could not be well appreciated by the DMC, because the DMC again is connected with the corporation. So there appears to be a probability, as per the preponderance of probability, there is a probability that there will be miscarriage of justice. Because his lordship, even let us take the case of a bias. His lordship, late Justice Bhagwati of the Supreme Court, when he retired in 71 or 70, say in the 70s somewhere, he openly said on TV that you cannot get absolute justice. Justice is not something that there can be absolute justice. There always is a bias in the mind of including judges. Even though judges are well trained not to entertain bias, nevertheless, certain element of bias is always there. And if there can be bias in a specially trained official, of a judiciary official, how much more bias will be there in an administrative official? Because the DMC is an administrative, it belongs to the executive part of government. He's not a judicial officer in that context. He belongs to the administrative part of the government in as much as he's an executive. And therefore there is bound to be bias. Then the principles of natural justice have not been then there isn't a speaking order. So many good points are there where you can agitate on those points and get a favorable order if you know how to present your case. Now here I'll take you to the case law. Where is that one? Case law किधर है? Shift it. क्यों नहीं हो रहा है? Shift. Yeah. Yeah. Now is the case law visible to you? Hello.
Yes, yes.
Yes, yes,
Yeah.
yes.
The case law. This is the case law I like to present to you. It's of course a very old case law. Nevertheless, it gives you a profile idea of what exactly happens in the High Court of Judicature at Bombay, Civil Appellate Jurisdiction, appeal from order number. This order will be an order of the DMC. Order number 110 of so and so. Okay, you put the name, number of the order and the date, and you come in appeal against that order. And when you come in appeal against that order, see here, this is the case. Sri Ramavatar Babulal Jadojia is the appellant. He has come in appeal against the order of the DMC. But you won't write there, DMC will write there, because DMC is functioning for and on behalf of the corporation. So you write the respondent becomes the corporation there. Municipal Corporation of Greater Mumbai. Now, who are appearing in the matter, that is the advocates' names have been put up there. Yeah. The appellant, original plaintiff, has challenged order dated 14/10/2013, passed by the learned judge, City Civil Court, Borobli Division. No, sorry, I made a mistake. 1 minute. I'm not taking a different order. This order is appeal from the City Civil Court at Dindochi to the High Court, to the Honorable High Court. From the Honorable City Civil Court, it got first appeal will be from BMC to the City Civil Court. Second will be from the City Civil Court to the High Court. Now this is come from the City Civil Court to the High Court. Here the applicant, original plaintiff, has challenged order dated 14/10/2013, passed by the learned judge, City Civil Court, Borobli Division, Dindoshi, Mumbai, where his notice of motion is dismissed. These people can get this order. This order, if you want, the viewers can get the order. They can download it. No. Okay, after this. Okay. So if you go to this case, your various types of arguments have been advanced. Already by the assistant commissioner in respect of the suit premises. The plaintiff, on the date of impugned order, notice order, admittedly being the owner of suit premises, again survey number so and so with the structures with village Parle, Taluka, Andheri, doing the business of selling marble. Okay. The applicant is in use, occupation and possession of the premises as per the rent receipt prior to first 95, initially a tenant, and later on a lease deed dated 21st 3rd 97, and now in view of registered conveyance dated 6 May 2004, the owner of the property. So the applicant, who earlier was a tenant, subsequently became a lessee, and pursuant to the becoming a lessee, the property was conveyed to him by way of a conveyance. So now he appears before the court in the capacity as a owner of the property. The notice under section 351 of the BMC. So he has traversed from occupier to tenant to lessee and to now owner of the property. The assistant commissioner dealt with the Xerox copies of 12 documents filed by the appellant and not accepted the same by giving 1 or 2 line remarks. Now here you notice 1 or 2 line remarks, and thereby decided the reply and the case against him. Okay. Admittedly, the suit premises fall within the declared slum. Now here they have tried to, the corporation has tried to invoke Slum Act also, because they wanted to demolish the structure by hook or by crook. So they have tried to invoke a Slum Act when the Slum Act actually wasn't there at that time and in that area. How could that be slum? It was a tenanted property. It was a building. It was in the Gautan. It was. So if you look at all this, we find that they were just creating hurdles for this appellant. But the appellant got justice when he went to court. The appellant, being the owner, cannot be. This is what the court says. The appellant, being the owner, now, because now the appellant is an owner, cannot be treated as unauthorized occupier. That is put in inverted commas of the suit premises. the owner of the property, in my view, cannot be compared with the unauthorized occupier of the property. The structure, even if unauthorized, has sought to be averred and contended by the respondent corporation, still just cannot be decided by. Still, the document so placed on record, including the existence of the structure, whether ground floor, first floor, just cannot be decided by referring to and on deciding the issue in such fashion by the assistant commissioner. The basis on which the learned judge has also passed the order, the approach of assistant commissioner in the background to decide and conclude the issue against the appellant, who is the owner of the property, is also debatable. The reasons so given as reflected in the order passed by the assistant commissioner, in my view, are also self-contradictory. The judge goes on to say that the order passed by the commissioner, by the assistant commissioner, by assistant municipal commissioner, of course, in my view, that is what the judge is saying, is self-contradictory. The documents which are prior to 1st 95 just cannot be rejected by a single line finding. Basically, when the same are of the years ranging from 1990 up to date, there is nothing on record to show that the assistant commissioner has passed order on 18th 2013 by giving any personal hearing and or opportunity to the appellant through though the reply was filed. So here we find that we 351 notice. One thing you may notice over there in this paragraph 8, it says the assistant commissioner. That means the hearing was held before the assistant commissioner. I am doubtful. I think this could be possibly erroneous reporting, or I may be wrong. I don't know. Because in my time, we always had hearings in this respect. When 351 notice came, hearings were always held invariably before the deputy municipal commissioner and not assistant municipal commissioner. I don't know. I could be wrong because things might have changed over a period of time. I'm talking about some 30 years back when I used to appear. So this order has come from the corporation, whichever official, whether he is a deputy municipal or an assistant municipal commissioner. So one of the officials was sitting in a quasi-judicial capacity. The appellant has challenged the order before the city civil court, and again it was challenged in the high court. And the high court is of the view that the appellant is right. So eventually you get a good order. You see, you go through the order itself, you'll find out it is in favor of the appellant. Therefore, see the last paragraph, 12. Therefore, taking overall view of the matter and considering the above facts and reasons, I am inclined to interfere with the order so passed. Order dated 14/10/2013 is squashed and set aside. The notice of motion is allowed in terms of prayer A. The appeal from order is allowed accordingly. However, considering the facts and as the notice is issued under Section 351 of Mumbai Municipal Corporation Act, it is desirable that the suit be expedited and disposed of preferably within 9 months. No order as to cost. Okay, now here again another important factor to be taken note of is Section 351. Now, can you tell me what is Section 351? Anybody? What is Section 351 of the BMC Act? Anybody? Try.
Regarding unauthorized construction.
No, not 351 is a section that if you want to sue the corporation, if you want to proceed against the corporation in a civil suit, you it is essential and mandatory that you serve them a notice under Section 351 of the BMC Act or Mumbai Municipal Corporation Act. Now it is changed. Bombay has become Mumbai. If the notice is not under 351, they can wriggle themselves out of the problem. Most advocates are not using this 351. I don't know why. They feel shy to use it. When there is an express provision stating that if a notice is not a statutory notice, the corporation and the government is not obligated to take cognizance of your grievance. Supposing I was defending the corporation, if I was a advocate on behalf of the corporation, or if I was a government pleader, I would, and this section 351 wasn't there in the notice, I would stand up and demolish your case in 1 minute. I would insist with the judge that this section, they have not served a statutory notice and therefore my corporation has not complied with it and my corporation is not legally obligated to comply with it. That kind of defenses I would have raised. But this section 351, remember, it is only applicable in a suit for suing. As far as criminal prosecution is concerned, no question of statutory notice is required. So there you will need sanction under 397 if any illegality has been done. But for that sanction also case laws are there. Normally sanction under 397 is a general sanction for any government servant. But there are various other sanctions also. If any government servant does anything wrong or illegal, you can prosecute them criminally. Now here it is a case of civil prosecution. In the case of criminal prosecution, you will need sanction under 397. In the case of civil sue, if you want to civilly sue the corporation as a body or its officials, you will have to use 351. 350. You will have to give a notice under. You will have to give notice under 527. 527. 527 notice. Notice will have to be under 527. And if the notice is coming for demolition, then the court is of the view, after giving you protection, reasonable amount of protection, either ad interim or a protection up to disposal of the suit, any one of the three. But here, since this issue is pertaining to 351, therefore the honorable judge has passed an order. It is desirable that the suit be expedited. So you automatically got expedition of the suit also, which I don't know whether it was prayed for or not, because I have not seen the prayer clause. But even without a prayer, the honorable learned judge has been kind enough to grant expedition of the suit, which otherwise you would have to make a separate application. Notices under 527 are given when you are suing the corporation, when you go to, but this is not to be given in the case of a writ petition. Petition doesn't need a notice. When you file a writ petition, many people say that, this is the final order, it is final appeal. There is a provision in the law that says you cannot appeal further. That provision in law is misunderstood. When you say you cannot appeal further, it doesn't mean that you have exhausted your source of appeal. That is not applicable to writs. Writs are governed by the law of writs. This is governed by the CPC. The civil procedure in the civil suit is governed by the CPC. That is on a separate footing altogether, and this is on a separate footing altogether. So if you're going by the writ petition and making the corporation a party, then you can dispense with that 527 notice. And sometimes in certain urgent matters also, there are rules of various courts. High court, city civil court have got their own rules of functioning. There, you need not wait for a period of 1 or 2 months, because statutory notice under 527 it becomes mandatory to wait for 1 month or 2 months, as the case may be, depending on different nature of disputes. Sometimes the waiting period is 1 month, sometimes the waiting period is 2 months. But that can be dispensed as per rules. That you will not find in the act, you will find it in the rules. And not municipal rules. You'll find it in the High Court or City Civil Court rules. They have got a separate book of rules for themselves. So you can dispense with that if your matter is very urgent. File it today and get a hearing tomorrow. It is not that you have to wait the mandatory period has to expire and then only you can get relief. You can get relief the very next day or the same day. If you file in the morning, you can get relief in the evening. So I hope you got a fair idea of this. And one more thing I wanted to tell you is, if there are various ways of abusing the law, which I will not suggest to you, but these should be curtailed as far as possible, because then if it is curtailed, it will be nice for everybody. It will be nice in the interest of the nation. It will be nice in the interest of advocates, in the interest of litigants as well. Because here there is scope to tell lies. They say that you have to only give you have to serve notice. Now the question arises, if you examine the entire BMC Act, serve notice means what? Sometimes the notice is to be served in writing. Sometimes notice can be served even orally. Sometimes notice can be served. There is a matter of saying mere tendering a copy of some notice, whether the other party has accepted or not, is immaterial. It is deemed to be served. Now, if there are such definitions, you're playing with fire. You'll create more and more problems than resolve. Because some people will come who have got ulterior intentions with them, and they have a wicked and deceitful mind. They'll say, I gave you the notice. I have served you notice. I have left the notice on your table. But that is not the way to serve the notice. There should be an effective service. Merely sending them, I can give some notice to when you. Let us compare this with, supposing I am getting married. I cannot carry my wedding cards and give people give my friend in the train or bus. If I meet my friend in the bus, I'll say, yeah, this is a card. I am getting married on those day. This is not the way. There is a system. You have to go to his house and invite him in a formal manner. So also with this, if a notice has to be served, it has to be served at the official registered address of the corporation. A notice has to be served. I have to take an acknowledgement of its service. Otherwise, there is scope to cheat. So this, in the interest of the people themselves, we should stop this. Because this is detrimental to the cause of justice. People can abuse the law. Sometimes individuals are cheating the corporation. And at times, of course, corporation officials also are cheating people. But that's wherever there's a loophole and we can improve upon it, we should amend it. Now, can I take questions? I hope I will be able to answer some of them, because if a very intricate question comes, I might not be able. Hello? Hello?
Yes, sir.
Can I take questions now?
No, sir. There is no any questions.
How many people are present? How many participants are there?
Just a second,
Hello?
sir. I will wait.
Huh?
Check. I will check.
Nobody feels like asking a question. That means everybody is understood. Either everybody is understood or everybody is not understood.
सर बेसिकली
Sometime
यूट्यूब पे है थोड़े बहुत लोग लाइव पे, पर अभी तक किसी का क्वेश्चंस वगैरह कुछ आया नहीं है, और यहाँ पे वेबएक्स पे भी कुछ क्वेश्चंस नहीं है।
ऑडियंस कितना है?
एक सेकंड चेक कर दो।
Can find it? You can find out from there how many audience.
51 के अराउंड है सर.
Here in Cisco, there
अच्छा.
are 5 to 6 people, and other are in YouTube.
YouTube, अच्छा. Okay, then we'll call it
अगर
a
किसी का
day.
सवाल हो तो मिस्टर मिरांडा सर से बात कर सकते हैं. अगर किसी का सवाल हो तो मिस्टर मिरांडा सर से बात कीजिए. नो सर,
Okay, we'll call it a
कुछ
day.
नहीं है.
Thank you for giving a patient hearing. I hope I
Yes,
did
yes.
not bore you people.
ओके.
Disconnect. हम Ladaria. Joginder. 14 this is which? 14 people are there.
Yeah.
And here
Sir, Kuldeep Singh here. May I ask a question?